If the defense makes a settlement offer and you turn it down, can you later change your mind and go back and ask for that settlement offer? You want to know what this is all about? Come join me as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, it's nice and hot out here today. I'm just in the middle of a bike ride and I had a few minutes to share this great information with you. All right, so now during the course of your medical malpractice case, as your case is approaching trial, the defense comes to us with a settlement offer. I immediately reject the offer because I don't think it's appropriate. I tell the defense attorney we need significantly more money. I then relay that information to you to tell you exactly what the offer is and to tell you my opinion and conclusions about whether or not I agree whether you should accept it or not. Now, you turn around and say absolutely not. It is not sufficient. Now, over the next course of weeks and months, as we get closer and closer to trial, you have a change of heart. You realize you don't want to go through trial. You realize you don't want to spend the time and energy to prepare for trial and for cross-examination. And you don't want to come into court each and every day over the next 3 or 4 weeks and sit there each and every day, listening to the testimony, taking time away from you and your family, to go through the entire trial expecting a jury to give you a verdict in your favor. And now, as we get closer to trial, you have a change of heart. You turn around and say to me, you know what? That offer that I initially rejected, I'm beginning to like that. I like that offer a lot. And I give you my opinion and advice about it, trying to accept that offer at this point. I tell you what it means from a strategy standpoint as well as a credibility standpoint. Remember, we have already rejected the defense's offer. We told them that your case is worth significantly more. And now, as we're approaching trial, you now want to go ahead and accept that offer. What does that mean for you and your case? It means that the defense will know, number one, that you have reservations about going all the way to trial. It means, number two, that there's a weakness here that they are now looking to exploit. Number three, they will recognize that they can try and get this case settled at a discount compared to going all the way to trial. So can you do this? Can I go back to the defense and say, hey, wait a second, remember that offer you made a few weeks ago? My client had a change of heart. We'd like to accept your offer. Is the offer still on the table? The answer is maybe yes and maybe no. There are some attorneys and some defense firms who turn around and say, you know what, if you're not going to accept our offer, that offer is no longer on the table. However, you will find that some of the best trial attorneys who represent the doctors and hospitals in these medical malpractice cases, that once they've made an offer, the offer is on the table. Oftentimes the defense is more than willing to go ahead and reconsider their offer. Why? Because now it minimizes and limits the risk that they are exposed to. If they don't have to proceed through to trial and a verdict, now the risk that they could possibly be exposed to by getting a jury verdict over and above what they initially offered or what the case might actually be worth, now is significantly reduced. Why? Because if you go ahead and accept their offer, now their risk is limited to the amount that they have offered. They might come back and say, I'm sorry, that offer is no longer on the table. At which point, now we have to ask them, well, what offer is on the table? If the answer is, I'm sorry, there's no offer on the table, well, now our answer is simple. Now we simply go forward to trial, take a verdict, and now we deal with a jury verdict. If, however, they come back and say, no, our offer is now X dollars, which is less than what we previously offered, now we have to have another discussion about whether or not this offer is appropriate and whether or not it represents the real value of your injuries. So why do I share this great information with you? I share it with you because this comes up from time to time where at first you thought that the offer was outrageous. You thought that the offer that they gave you was absolutely horrendous. And now, as you are getting closer to trial, and now I have to prepare you for trial and all the steps that go into getting your case ready for trial, you begin to realize, you know what? You just don't have it in your heart to go forward to trial. You just don't have it in your heart to go through the entire litigation process and see it all the way through to verdict and to accept whatever the jury gives you. Maybe the jury gives you more. Maybe they give you less. Maybe they give you nothing. You don't want to run that risk. Now you want me to go back and accept their offer. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.